I think has been very much made clear by the argument and the made today is that there are several legal issues to sort through, several factual determinations that I have to make, and those aren't ones I can make at this moment. And so I will be taking the time to make sure that I give this case the full consideration it's due. I hope to have an answer for everyone within the next 2 weeks. Until that point, if there are any other issues that come up, counsel can reach out, and we'll have an order posted on the docket. Thank you all. We're off the record. Thank you, Mr. Chairman.
Hi, everyone. I'm Major Garrett in Washington. We have been listening to closing arguments wrapping up in the hearing to determine if Fulton County District Attorney Fani Willis should be removed from former President Donald Trump's Georgia election subversion case. Lawyers for Trump and other defendants in this election case are arguing that Fani Willis's romantic relationship with Special Prosecutor Nathan Wade, whom she assigned, creates a conflict of interest, material conflict of interest. Here on the set with me is CBS News congressional correspondent Nikole Killion, who has, of course, closely been following this case for us. So my summary of today, Nikole, is as follows. For the defendant's attorneys, there was synonyms for lying. You either lied, you misrepresented, meaning Fani Willis and Nathan Wade. You had a scheme. At one point, it was referred to as original sin, that they had a magic cash theory to hide all of their not only personal relationships but financial benefits enjoyed. The state said, you know what, we're going to come up with synonyms for gossip, speculation, innuendo, and meaning all of the testimony and evidence brought by the defendant's attorneys should be discounted. And as the judge, Fulton County Superior Court Judge Scott McAfee just said, lots of questions of law and fact. He will need at least 2 weeks to render a judgment. Your impressions?
Well, I think you summed it up perfectly, and I don't think we were expecting that he would rule from the bench today. And
not after that, not after 3 hours, back and forth.
And there's a lot to take in there, but you know, at the end of the day, Fani Willis's reputation, her case, is at stake for the next 2 weeks until the judge, until the judge rules. Same for Nathan Wade, who is a special prosecutor and has played a pretty key role in this case. And so what we heard largely from both sides is each side trying to poke arguments in the other, right? So, of course, in the case of the state, they contend that Fani Willis and Nathan Wade did not have any type of conflict. That the burden's really on the defense to prove that there was some type of conflict of interest here, that Fani Willis personally or financially benefited, which was part of the allegations that were initially brought from Ashley Merchant, the lead attorney in this case, who represents co-defendant Michael Roman. So they argue that, yes, while it may be speculation, while it may be innuendo, there was no conflict, that the testimonies of District Attorney Fani Willis and Nathan Wade were consistent in terms of when they met, which was at a judicial conference in 2019, which is that their relationship started in early 2022. After Nathan Wade was brought on board the Trump case, that yes, they did go on trips together. They did do that. The district attorney paid cash for some of those trips, reimbursed Nathan Wade, that the relationship ended in the summer of 2023. And so at this point, they continue to contend that neither one did anything wrong with respect of having this conflict of interest, which is why they argued at the very end that the district attorney should not be disqualified. The defense, on the other hand, obviously sees things differently, and so they are pointing to the witnesses that they brought forth, people who knew both Nathan Wade and the district attorney prior to Nathan Wade being hired, who testified, well, one witness who testified in particular, a friend of District Attorney Fani Willis, that they did have a relationship prior to Nathan Wade being hired. The second witness, Terrence Bradley, a former law partner of Nathan Wade, He said that he didn't recall. And he said that repeatedly, which is something the state pointed out. But that being said, the defense also tried to inject the fact that there are these cell phone records that they believe should be considered that put Nathan Wade in the vicinity of the district attorney prior to Nathan Wade being hired. Again, we heard the state try to poke holes in that, saying that those records aren't necessarily valid, and that is something the judge will have to take into consideration in terms of whether that should be evaluated. So again, a lot of arguments back and forth. Also worth noting that, as we see here on our screen, the district attorney was there front and center. We did not hear from her explicitly, which was a big question, considering that, you know, she was very resistant to testify during this evidentiary hearing a couple of weeks ago, but made that decision to explain herself. So I wasn't sure, honestly, if she was going to say something or not. But clearly, she wanted to be there to hear these closing arguments. So did Nathan Wade. So I think both of their presences there were certainly notable.
Nikole, stand by for just one moment. I want to bring in our CBS News legal contributor and Loyola Law School professor, Jessica Levinson. Jessica, as was said by both parties, this is one of the few things that both parties agreed to. The standard is direct conflict or appearance of conflict. They argued about whether that had been established, but that's really what's before Fulton County Superior Court Judge Scott McAfee. If there's a real conflict or a damaging appearance of conflict, well, under state law in Georgia, the district attorney has to be removed. Is that what this is really, in the end, all about?
In the end, I think that's exactly what this is all about. I mean, I think the way you laid this out in Nikole's analysis is exactly right. What I also heard is the judge, and to your question about the standard, really probing, have we ever disqualified just based on appearance? So certainly what the defense is arguing here is that an appearance problem alone is enough. And obviously that would be beneficial for them, not having to prove that there was an actual conflict, but having to say, isn't this a bad enough look that it might be enough of a problem that we shouldn't move forward, that the district attorney should in fact be disqualified. Whereas the state wants to say, no, you have to prove an actual conflict. And because of what Nikole was just pointing out, because of all of those questions about when exactly the relationship started, because of all of those questions about whether or not there could have been a financial conflict of interest, given the way that they seem to have split cost, Fani Willis and Nathan Wade, given the way that she seems to have reimbursed him. So that question of, is it just actual or is it actual and apparent, I think is a big one to focus on. In addition, I thought Cole was exactly right also to zero in on this question of whose burden, that the defense really does have to come forward with enough evidence here. I think all of those reasons are the reasons why we aren't going to hear anything for at least 2 weeks.
And Jessica, there was a conversation, a rather lengthy one, about Terrence Bradley. He had made representations about his knowledge about this underlying affair via text message, but his testimony didn't match that. In a matter of law, which carries more weight? Text messages to one of the litigants, meaning the attorney for the defendants, or what you actually say in the court proceeding itself?
Well, obviously, I think this is a credibility issue for the judge to weigh. And what the judge will be looking at is what we're all asking ourselves right now, which is, once you're under questioning and this hearing is starting, do you have more of a reason to lie or be less than forthcoming then? And or when you're engaging in text messaging with this attorney, would you have any reason to lie then? So that's really what it comes down to when you have this type of conflict. When do we believe your statements, and when do we think that you would have a greater incentive to lie? Now, of course, at this point, and or be less than forthcoming. And I think you were exactly right to characterize this as lies versus gossip. Now, in this case, the main difference is that it's not a jury weighing credibility. It's this one judge who's looking at whether or not the facts give rise to a conflict of interest.
Jessica Levinson, thank you so very much. Nikole Killion, my thanks to you.